Okay, what's going on, everybody? This is Greg Dawson, GD Non-Attorney Pro Se Consulting. I am here to do a video on how I successfully disqualified or managed to get recused several judges in a case I had back in 2017, which you can see on the screen, which is 17 CF, which stands for Criminal Felony 9089. And of course it's public record anyway, so let me go ahead and get some of these formalities out the way before I get into a little bit more of the meat of this video. I'm not an attorney. I do not have a license to practice law. I do not practice law. What I do is study law and tell people what I've learned, how I gathered information. That being said, if you think you need legal advice, I would highly encourage you to hire a licensed and hopefully competent attorney and be legally advised. But in the event that you find yourself, much like myself, charged, or I should say, build out of being able to afford adequate representation and definitely not trusting the public defender's office, and not that they necessarily would have done a bad job, but this one I didn't trust anybody anywhere, particularly within the jurisdiction, because of the principal parties in this case. One was at the time, now retired sitting judge, and as you can see I was kind of confused as to what to do. There's a sitting judge and a City of Tampa police officer who was actually in charge of the mayor's security detail that were involved in this case. So one day my business spirit universe told me, hey, you got a warrant for you. And I said, oh, I have a warrant. I haven't done anything. Lo and behold, I go and check and there's a warrant. And despite what some may believe, that's actually what happened. I checked for the warrant, called a bail bondsman who I know, and he thought it was just strange, and so I met him the next day because he said it probably wouldn't be smart to go that night, and I meet him there and I do the walkthrough. When I get there to do the walkthrough, the first thing I ask for is let me see the warrant, because I'm aware, as many people should be, and if not, then you can look it up and see whatever the protocol is in your state or the procedure in your state or local jurisdiction for issuing warrants, particularly felony warrants, which mine was a felony warrant. And they didn't show me the warrant, so I thought that was kind of strange. So I'm thinking to myself, I don't want to make too big of a deal about this inside of this walk-through jail situation. I go in, turn myself in, get printed, and leave. First thing I do is I file for discovery, and in the midst of discovery, I ask for the particulars as to what brought about this particular action. And I find out later on that there was an information file that spoke to my situation. So let me go ahead and go over a couple of these things as we do a little bit of housekeeping. Right here is what an information looks like. You see this, and here it is. Count one, me. They actually call me Greg, which is kind of interesting because that would mean that they are either familiar with my internet persona or something else that I was doing. But anyway, made a false statement which he did not believe to be true. To wit, he was indigent and did not own any real property under oath in an official proceeding regarding a material matter contrary to the form and statute and such, all this other blah 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 blah. Anyway, charged me with perjury. Now, we can get into this in another video. Didn't happen. Not at all. And what's kind of interesting, since they said this, that I was indigent, didn't own any property, which was not a question on the indigency application. This was about properties that I had lawfully acquired from somebody through a quitclaim deed. That individual had purchased the properties through a clerk's auction. So the clerk sold him the property, gave him a certificate of sale, gave him a certificate of title. He decided, for whatever set of reasons, that he did not want to defend the houses against the banks. And I said, hey, sell the house to me. It's nobody's business. We come with an agreement. He sells the house to me via quitclaim deed. Successful quitclaim goes into the court record, and next thing you know, the house is transferred from his ownership, because he was the listed owner in the court records, over to me being the primary owner. What's kind of funny about this is they began to slowly take the houses out of my name without affording me adequate due process or the ability to defend the properties, because of the superior versus inferior lien issue. However, in none of these cases was there ever an evidentiary hearing. That's just some things for those who may be familiar with that, but we don't have to get too much into that right now. We can tackle that later on. As you see right here, here's a direct file capias, which was signed by, at the time, the clerk of courts, deputy clerk, but here you go. So I had an active warrant out there for me. And they have all this other stuff in here on me and what have you. The City of Tampa Police Department is the one, as you can see here, issued the warrant. Now what's interesting is this set of events took place in the county courthouse. So the first thing most of us should be thinking is, why would a City of Tampa police officer be dealing with an issue that probably belonged to the county? We'll find out a little bit later on in another video, but as I go into more detail, here you have the criminal report affidavit. It's not a secret. This is all public record anyway, because I pulled it right off the file. And you can see my demand for discovery will go into my witness list, which, by the way, I named a couple of judges that were involved with the house situation. And let's see what this is right here. Oh, my notice of special appearance. That would have been filed probably sometime before my first appearance. Now, I might have filed one for every one of them. I actually challenging, which, you know, the issue of jurisdiction is kind of, let's say this, most times the court's going to have jurisdiction so long as you're duly notified of the situation and the court can hear that kind of case. Jurisdiction is a very difficult issue to overcome unless you can show that there's an issue of standing or something else that might be improper when it comes to jurisdiction. And if you don't know, you can always challenge jurisdiction and whether or not the court not only has subject matter jurisdiction, personam jurisdiction, but here in Florida there's a thing called case jurisdiction, which is not necessarily written into the law, but there's an understanding is, do you have jurisdiction to hear this kind of case given this set of circumstances? Which in this instance, the court shouldn't have been hearing the case because the maximum punishment based upon, even if there was a violation in the indigency application, would have been a misdemeanor at most. But let's go into that now. Let's see what this right here is. This is my, okay, we'll get into this in another video, but essentially once I disqualify one judge, I have the right to, once I get a new judge, to reconsider any orders issued by the prior judge. So you can imagine how often we went through this, and I'm going to show you the court file in a second, but let's go ahead and make this a little smaller. And before we hear the audios, let me show you what the court file looked like. Here, why would we do this? What did I just see? Okay, let me get rid of you since I guess I was out of it too long, so let's do this. Let's come back into the Holder, which is Hillsborough County, Florida's clerk site, which is how you find any cases, but since we're looking for only one case right now, let me log into this. Okay, there we go, now I'm in. So we're at 17 CF, what did I say, 9089, right? Oh, there you go. State of Florida versus me. My given name. There you go. Perjury in an official proceeding. I don't know where this $50 comes from because I didn't use anybody. I didn't use a state attorney or anything. I mean a public defender. That's kind of interesting. So let's go here. This is the case information, and again, this is something that anybody in our area could do. I don't know, different jurisdictions may have different ways of doing things, but let's just go here. You can see my bond. It's probably going to come up $2,000. See the surety bond. And in fact, a bond was also put up against this by the state because of the fact that they actually had charged me with a felony. So they took liability in the event that I won, which I'll get to show you my demand letter in a little while. But the warrants, this is populating at a very slow speed. So, but we know there had to be a warrant because I turned myself in on a warrant. Oh, no warrant information found. Let's see. Let's look at the charges. Once again, perjury in official proceeding. third-degree felony. And as you can see, the case was actually dismissed. I don't know why Judge Barber is here, because he's not the one who dismissed it. In fact, he tried to keep it going. Let me go over here. And again, I'm sorry for moving myself out of the picture, because it's always more about the story than it is about looking at me. I just think it's important to tell people that sometimes things go on that may sound fantastical, and a lot of people may tell you stories about what they heard, or what such and such said. So I'm sitting next to the man, sitting next to the man, sitting next to the man. In these instances, these cases actually involve me, and for whatever reason that the universe charged me with the task of having to walk through some of these things, I nonetheless walked through it. And trust me, I was thinking about attorneys and everything else when I found out about these charges, because again, I was facing 5 years in prison had I been convicted. So let's go here. See this judge assignment history right here? There you go, people. Now here is a list of the judges. I never had Judge Taylor, but here's a list of the judges that heard my case. And you see the 1, 2, 3 recusals. This judge actually heard it, and this judge recused himself without even fighting about it. He just said, hey, he's out of here. And there's a reason why he did that, and we'll find out. You all look at these names. You see Judge Wolf, you see Judge Nash, you see Judge Kaiser, and the presiding judge was a visiting judge named McGrady, and you see a judge by the name of Thomas Barber. Now, the judge who was on the witness list is Judge Gregory Holder, or was Judge Gregory Holder. So let's go back down here and try to find this case. And as you see, there's 187 docket entries for this case. That's a lot of docket entries. For anybody who's ever been through anything, you'll know that that's a hell of a lot of fighting. And this went on for 7 months, by the way, without me being able to get much of a legitimate or good discovery. I nonetheless managed to get through this case. But during the course of this case, there's a couple of legal terms, and we can get into this later, but you all can look them up, where they filed traverses and demurs in the case. So, and as you start to see some of these, I had exhibit lists, probably related to the house, but I had to create a exhibit list because I wanted to challenge all the judges who had something to do with any of the house cases, because it was important for me to figure out what is it that was going on that I must have pissed off this many people that you all essentially coalesced to come out and get me. I acquired the properties legitimately, but I guess that must have pissed some people off. Nonetheless, you can see everything that was filed here, and in fact you can see right here, accuses himself, blind transfer. You see this? They did conduct a Ferretta hearing on me. That's actually, if you want it, you reach out to me, go online and get the Dropbox, support the channel. I'll probably just send it to you, and you can listen to how they conduct a Ferretta hearing. You're going to hear him mention, Judge Wolf mention a Ferretta hearing, and you'll also hear something very interesting said that I did not hear at the time that I was standing in front of them because of the distance from me to the judge. But the hot mic picked up something that was said about me that's definitely not true. And if I haven't said it before, I am a veteran of the United States Army. So let's go into another one of these pages. Let's see, we're on page 7. Yeah, come on. Let's see. Writ of prohibition. Yeah, that was against him. Okay, without counsel. Notice of hearing. I want to see a copy of the state's witness list, because the state's witness list is what will show who they brought up to be to help them prosecute me. And oddly enough, the judge was on the list. Now you see this order for competency, sanity, and psychological evaluation. That's some foolishness, because one of the questions that was asked during the Ferretta hearing is, have I ever been diagnosed or have I ever been evaluated for mental disorder or something like that. I don't know. I don't want to mislead you, but it is. You can hear it on the other file. Everybody who's been in the military, as part of your out processing, gets some sort of psychological evaluation. That was just some foolishness that I guess they wanted to use to try to get me to get an attorney. And by the way, I did all this in the same courthouse that O'Neill guy who killed his girlfriend and her daughter, that they had all the national news for. I was in the same courthouse, and I'm pretty sure most of y'all didn't have any idea that this went on in that courthouse. So that was a bunch of BS. Let me see what we have going on here. Defendant's exhibit. Let's see this. Minute notice of hearing. This motion to disqualify judge may actually apply to him. This writ of prohibition, which should have been filed in the second DCA. Okay, yeah, it was. There we go. And the second DCA, you'll hear me mention that they dismissed it, but the reason they dismissed the writ of prohibition was because the 30 days that the judge had to answer it had not expired. But I'm pretty sure they were going to end up granting it anyway. He got up off the case. But by the way, if you want any of this, you're always free to do exactly what you see me doing and get the case, get the whatever is filed into the case. But I do file all my documents and I create them organically, which is again an awful lot of work involved with this. I did a lot of studying and a lot of okay, this is the second DCA's page showing that it was actually confirmed. You can actually e-file a brief, a pleading, what have you, into the second DCA from here also in Florida, which is really convenient. And then they charge you back or what have you as far as if there's any cost involved. But I'm trying to find their witness list because it's going to be kind of interesting. And it was at this time that a birdie got into my ear and said, there is no way that they're going to allow you to question a sitting judge. Again, you see this notice of appearance in this statement of non-corporate existence. That was, let me say this about a lot of this stuff here. I haven't seen or found anywhere where any of this stuff is beneficial. And by the way, this right here would not even be binding law unless it came from the United States Supreme Court. It may be construed to be persuasive law because it didn't come out of a Florida court. But what you want to do in any case is, and again, this is not legal advice, you want to find a case that comes from your exact jurisdiction, a appellate court in that jurisdiction, or of course the United States Supreme Court makes it binding, or if not, well, let's go before the United States, your state Supreme Court, particularly when it relates to criminal issues. Those issues are what you can say your boss said. This is what any decision in those cases, you can say your boss said this as it relates to this kind of situation, and then they have to follow it. Well, they don't have to, but if they don't follow it, you preserve your right to appeal, and then you come back and you more than likely will be able to get a favorable ruling through the appellate process. And here's another motion to disqualify, another special appearance. More motions to compel discovery and evidence, which I wasn't getting. And I'm just trying to find a motion for particulars. Now, this is actually something that you can use. And my writing has definitely evolved. I'm much better at sticking to the facts stated in plain, simple statements. But essentially, it's like an upgraded discovery or a motion to compel that's built into a discovery from what I've learned. If there's an attorney out there listening, he could probably clean that up a little bit. But if there's an attorney out there and you're probably not from this area, you may want to give me a call because I'm getting ready to file the lawsuit. I've already duly noticed everybody, but I'm trying to find, and by the way, I like having these assistant state attorneys here. They have an obligation to not just seek a conviction, but to seek justice. And what's very funny is when we do get to the video where I do about the actual perjury hearing, the one that was dismissed by the visiting judge, you'll see Mr. Ricardo Martinez backpedal faster than a 1980s SWAC cornerback when it came time to accepting responsibility for what this is. You know, it's kind of crazy. I cannot find the... Oh, by the way, you see these other motions to set aside the prior trial court's judges' rulings. I think I did that at least 2 or 3 times in this particular case. Change of venue. This probably would have fallen in line more with the writ of prohibition, but throughout this process, the circuit's chief judge, sorry for that delay, the circuit's chief judge, I'm trying to find their witness list so that you can actually see where the judge is listed as a witness. Let's see if this is it right here. And I apologize. Okay, well, it failed to load. I don't know why. We're active. There we go. Okay, here we go. Oh, John McDarby, just another. He was a detective. I don't even know what the heck he was doing. But now, here's something else that they should have given me. Along the way, I asked for all information regarding the investigation. And what I learned from a deputy was, or I think it's a deputy. Yeah, I knew he worked for the sheriff's department. Well, he has to be a deputy in that sense, but I don't know what his other job description was within the department. There should be like an assistive agency, because the Tampa Police Department actually went out to one of the properties that was in the county area. So for that police officer to go out there, he would have had to have had some sort of permission to go out there to investigate something that belonged to essentially the county. That was my understanding. I know that once we get through this discovery and I get a lot of their policy books, I'm going to find out a whole hell of a lot about why and how he managed to get out there. And again, this guy is not just like a vice detective at the time. He's a part of the mayor's security staff. So I want to know why the mayor didn't know that his security personnel was out here doing an investigation, a rogue investigation with a sitting circuit court judge. Notice of intent to allow certification. But okay, his business record. This is what was also interesting. Somehow they managed to get the business records of Wells Fargo Bank related to one of the tenants. What I thought was kind of odd about this was on one of the documents I could see the lady's social security number. I don't know if she knew that or not, but they scared him up pretty good, and I guess they managed to get what they wanted. So there's a whole lot of money, as you can see, spent to get after me. And maybe this is more urban myth or what have you, but I would be one to believe that if somebody is really good at something, at some point they should at least have encountered something similar to this. Hopefully they don't, but it's just really weird because I just didn't do anything. I just started standing up for myself, and I guess I went on a pretty good track record, and I went on a pretty good run, which I didn't want to run. I'd really just leave me the hell alone. Nonetheless, in doing so, the response was this. So let's see this right here. Now see, here is where the copy of the order given to Judge Figueroa's office is ordered to consider that an out-of-court judge be appointed. Now, this is, I think, where he denied order of disqualification. Oh, he did. This is when he did disqualify himself. What was interesting is inside of his chambers, and I don't have the audio for his because I was told that all of the courtrooms don't have the same setup, which is strange even in 2017, that would have allowed me to get audio from each one of the judges. So some of it will be just transcripts, which I can get those as well. But if there was any audio, they should have preserved it once I won the case, because essentially they should have known that a potential lawsuit was coming from it. And depending on the circumstances, you have a right to, they have an obligation, I should say, to preserve evidence and information. So let's see what else we got here. I'm going to go back and look at that original. Oh, let's do this right here. Let's try this one here. The state's response to what was it? Motion to particulars, not for particulars. Let's see if this is it. Additional witnesses again. And again, okay, see all these people, Hillsborough County Clerk of Circuit Court Custodian of the Record, all these people that they got together to find out whatever they could find about me. I don't know if this is done as a boo game or this is just what they do. But as you can see, they put in a whole lot of man hours. A whole lot of Hillsborough County taxpayer funds went into this. Why? I don't know. I mean, I don't dislike the Bucks or anything. I don't like the Gators, but I guess it's a different issue. But I don't know. So let's see the state's response to my amended notice of discovery. And you can see it. Here you go. Here you go. Amended discover. Okay. The state is not in possession of any documents related to the Honorable Judge Holder, which is kind of crazy because he was actually, what's it called, by the Supreme Court. He was reprimanded. And I didn't realize he had been reprimanded as many times or had as many, I guess, whatever grievances filed against him. But it's kind of interesting that Judge Holder is also the same judge who, when another veteran went into a convenience store and urinated on the floor and then rode up the road firing his weapon, worked extra hard to get that veteran sentenced, or get the state not to pursue prosecuting that veteran, and also went to the University of South Florida to try to get this veteran back in there after this felony conviction. Oddly enough, I know another person who's a veteran that Judge Holder worked extremely hard to try to put in prison. I don't know what the differences are between the two of us, although I do, but that would be speculation for me to think that that's the only reason he did it. But you all can look that up, Judge Gregory Holder. So you might find it to be pretty interesting as well, because it's about time for me to get on to filing that lawsuit. Let's see the response to my statement of particulars. And here we go. Let's see, sign up in court, Defendant was also shown in court the unredacted criminal report affidavit showing Holder. Oh, here you go. Look at this. So here we go. Now let me do some more to get to you all's curiosity. Judge Holder, Gregory Holder, as you see now in G, defendant was also shown in open court the unredacted criminal report affidavit showing Gregory Holder as a complainant witness. Now, here's what's interesting, people. Judge Gregory Holder was a judge actively on a case that I was attempting to intervene for one of the properties. He was the sitting judge in that case. So in other words, a judge who was sitting in a case involving me, or me making an attempt to get property, is the witness who started the investigation. So if I got any great civil rights attorneys out there, or any, well, you have to be a civil rights attorney for one, because I'm definitely going to file a 1983 action in this case. But it's kind of interesting. The judge in my case actually created a criminal action against me. Something else, during this process, this same judge created a case management conference. For those familiar with Bill Cosby, you might be able to follow along with it. The Bill Cosby situation. He created a case management conference. In that case management conference, he asked me questions. Didn't know judges did that kind of stuff about my acquisition of the property. What was very interesting at the time was I filed I think Second DCA called it a writ of review, which is kind of like a certiorari. They pulled the case away from him, so we were sitting in the middle of the stay. But he called a case management conference during the stay and was doing all this stuff, even though, again, the Second District Court of Appeals, DCA means District Court of Appeals, said, don't do anything else with this case. He called something. He admits during this case management conference that he had witnessed me in another proceeding about another property. Oddly enough, people, in that case, one of the judges that he was sitting in front of is a judge that I sat in front of. That may not make sense. He went to a judge's chambers to actually investigate and watch me. Why, I don't know. And in fact, the house in question in that case that I was attempting to intervene to defend, the attorneys for the bank filed they filed the foreclosure more than 5 years after the last default date. Florida statute says you only have 5 years. So essentially, some lawyers and some judges stole at least one of my houses. I think they stole 4 of them, is what I'm going to say. He stole 4 of my properties because you never had an evidentiary hearing. The fact that an attorney came in and filed a complaint wasn't going to be enough. Not to mention those properties are also part of trust. So how could the trust be intact if you snatch the property out? That's just some more underlying stuff as we get to me disqualifying the judge. But I'm pretty sure by now everybody should understand why it was necessary to disqualify the judge. So what we're going to do here is, because I wasn't planning on speaking this long, but I began to pontificate. But let's get to the actual proceedings, and you'll actually hear the judge disqualify himself. But look, what I want you all to do also is turn your volume up as loudly as you can, because you're going to hear something that, again, I did not hear at the time. I did not find out about it until I got a copy of the audio that something was actually said regarding me during this proceeding. And let me see if I can't hit this mic mute thing. Because otherwise you're going to get the feedback from this microphone. So with that being, what's the mic mute? Mic mute. Let's see if I can find it. Because I don't want it to pick up the background noise. That's what I need right there. And I appreciate you all waiting patiently with me as I go through this, and hopefully you'll find this to be a pretty intriguing, very interesting situation. So let me do this. Mic being on.
Page 23, Sturgret Doss, Miss Isabel for the state.
For the benefit of the court reporter, I asked that the attorney state their appearances for the record.
Yes, Judge. Defendant in this case is pro se. This is a case where Judge Kaiser recused himself, and so it's here for arraignment.
All right. Why are we calling it the pro se case first?
Because it was requested by the bailiffs.
Oh. All right. Well, I guess first thing I do, Mr. Doss, are you planning on hiring an attorney?
No, sir.
Are you going to be, do you wish the public defender to represent you?
No, sir.
Okay, then I have to pass it, because I have to do a full Feretta hearing.
Okay.
All right, you have a seat, sir, and I'll call your case.
Here?
I have to have a full Feretta and/or Nelson hearing before I can allow you to continue to represent yourself. So have the seat, and when I get done with the regular cases, I will call you back up.
It's fine, just so you're aware, he's a sovereign citizen.
He's what?
He's a sovereign citizen.
I can't hear you.
He's a sovereign citizen. And he's
Oh,
gonna make a statement.
that's fine, but I
it's
have
okay,
to,
you do what you
I'm not going to go through a full Feretta hearing until I get the rest of the people out of the courtroom.
No, that's fine.
Okay.
Just so you know. Yeah, we're okay with it.
You may proceed.
Thank you, Judge. Page 13.
Now, I don't know where they got that from other than maybe some foolishness. One, I don't qualify as one. I've never done anything against this country other than serve it honorably. And I could probably show a picture of me in my military uniform, which is kind of interesting. Now, this is also interesting. Look at the backdrop right now. They were having some sort of, what's it called? Faith and ale meetings. And if you look really closely, oh, don't do this to me. Look at the names that were here. See this guy here? Now, who am I in front of right now? And who actually recused themselves? And who had I been in front of one other time before? It's kind of interesting. They all were buddies hanging around, but we want to play this game about recusing, right? I shouldn't have had to say one word. They knew good and well that there is no way in the hell I should have been heard by. My case should have come before any of them without them all just getting up and saying, hey, look, we can't do this. It shouldn't have taken what ultimately happened for that case to be sent to another judge in another area. But that comment about sovereign citizens is really interesting. And again, I was some number of feet away from where the judge was actually sitting, even though I was standing in front of him. So I couldn't hear what was being said to him. But we'll get into a lot of that later on, particularly when the lawsuit comes about. I'm sure you folks will find that to be relatively interesting. So let's get to the part where he actually recuses himself. And by the way, I sat in that damn courtroom for about 3 hours that morning, waiting for him to recuse himself, because they had to go through a process. And when I walked in, and I had to get the entire audio, the whole set of proceedings. Well, he'll say something like, well, eventually we have to deal with that. I guess I was the that, because I had to wait till the end to almost noontime, I think it was, and I got there like at 8 o'clock. But let's get to this second part.
Page 29 of the ready screen. Sir Brett Doss.
Okay.
Miss Isabel.
Judge, the defendant filed 2 emergency writs of prohibition and a motion to dismiss.
Okay. Well, I don't have jurisdiction once they file a petition or writ in front of the second district.
Judge, my only question about that, and I would agree if that's the case, I just couldn't tell if it had been filed with the DCA or if it was just sent to us. Maybe Mr. Doss can answer that for us.
Mr. Doss, did you file a motion in front of the second district?
Yes, I did, and moreover, I'm here in the special appearance. I thought I was the last time. It's been filed, but in keeping, to be honest, since I'm trying to hope to get more of that around here from this district, it was already dismissed.
It was what?
It was dismissed.
What was dismissed?
The red prohibitions.
Already?
Because you have 30 days to deal with the motion to disqualify.
Well, I don't, right now, all I see is your motion. Here's an order from the DCA on 9/25, okay? Let's see what they said. The petitioner's petition for writ of prohibition is dismissed without prejudice. Okay, so was that the only motion that was filed to the second district?
As far as I know.
Yes, it is.
Okay, all right.
And then, Judge, there is a motion to disqualify. I know last time we discussed that I wasn't sure if you had been listed as a witness. I do believe you have been listed as a witness.
I've been listed as a witness in the case now?
Yes.
Okay, all right. Well, given the fact that I've been listed, now, the motion to dismiss, I obviously cannot hear once if I grant your motion to recuse me. You understand?
I'm going to understand. Let's do this. I know we're on the record, and I don't think the people in the back can.
I'm sorry, what did you say?
We're not on the record yet, and I haven't been arraigned, but
We are on the record.
we're on the record.
Yes.
Okay, well,
He's the record.
I understand that.
Okay, so you filed a motion to recuse me, and
disqualify
that is,
you.
and that's based on the fact that he has now listed me as a witness? Is that correct?
I believe that's his disqualification. I'm not sure.
That's one of the reasons.
Well, did you list me as a witness?
Yes.
Okay. Well, based on that, I'm going to grant your motion. All right. Now, what you'll have to, just wait a minute. We got it, Madam Clerk. It'll go back into blind rotation,
Yeah,
right?
give me a minute because I had to have help to do this.
Okay, all right. See if we can give you another court date and division, sir.
While they're doing that, and I'm going to let it keep going I'm not going to let it go in the background because you get the echo. That without prejudice means that I can come back and file it later. What he knew at that time is that I was going to get what I wanted. Because, and when he said, well, wait up, I'm pretty sure that I was probably making some faces because I have a tendency to mumble. And if you listen to my, my videos, the coming up video that I haven't finished converting, where I deal with Judge Artemis over in Plant City, I have a tendency to say what's on my mind, and I had to start working on that. Whatever I'm thinking, I tend to say when I'm aggravated with people. People who work for me, I think need to do what I ask, and they need to be a little bit more upfront. Like the comment that was made about, I said, well, in being honest, I think my comment, if I recollect and based upon what I'm hearing, was, which is more than I'm getting from anybody in this circuit. So I was going to tell him that I was already aware that the Second District Court of Appeals had already pushed down my writ of prohibition because this judge, Judge Mark Wolf, had not had the 30 days that the statutes provide him in order to rule on the sufficiency of the motion. And there's probably a bunch of reasons as to why I might have listed then. You know, now I would probably really light it up. I'm a much better writer, even though I've had a couple of them after that deny him. I just didn't have to do the writ of prohibition because I already know that once the writ of prohibition is filed, I'm going to get what I want anyway. And in the instance with the judges in the 13th and me, because I have this reputation, fortunately or unfortunately, I don't know whether they may want to label it. It's kind of difficult for me, particularly now, to get what I would think is a fair trial because of this situation right here. There were sitting judges that got together to help another sitting judge and a police officer conspire to deprive me of my right to freedom. Not based upon something that I did that was actually against the law. I was attempting to defend properties that I had lawfully obtained. I didn't squat. I wasn't an adverse possessor, which although adverse possession is legal in some states, I don't know the adverse possession laws in Florida. That's not something I've ever really studied. I was a legitimate owner of properties that I had lawfully possessed and had acquired. But let's get to the rest of this one right here, and then we'll go into the part of the proceedings. I'll go into more detail in another video. Part of the proceedings when the visiting judge dismissed the case. They're trying to find a judge to hear my case, so this dead space I apologize for. I didn't cut it out, but they're using the system to find a judge to hear my case.
That's the patient on Allen.
Oh, okay. Thank you.
And additionally, I would have argued that one judge in the 13th Judicial Circuit is every judge because they're all colleagues. It's kind of difficult for one judge not to know another judge, or have some sort of overlapping relationships with judges that they all, not that they have to like each other, but they're all within the same building, within the same circuit. And if you ask for it, and I'll send it to you, he actually admits during the first part, because these are 2 different days, the 126 one happened on one day during the arraignment, the second one happened after I came back a couple of times.
Court date is October 24th.
At what time?
9 o'clock.
All right. You get that, sir?
Yes, sir.
All right.
10/24.
9 a.m.
9 a.m. Judge Christopher Nash.
Judge, I believe the last thing we have, pages 3 and 4 of the docketed screen.
So there you go. So now he's done. So before when I got to Judge Nash, of course, I moved to essentially strike or reverse, vacate all the orders of the last judge. But as you can see, there was a successful disqualification of a judge, and as you also saw the entire docket, I did it more than once, and here's this thing going back up again with them. And this is October of, I don't recall the year. It might have been 18, but it doesn't matter. They had a relationship, and that alone should have kept them from even attempting to do whatever they were trying to do. In fact, the honorable thing I would think would have been for them to tell Holder, hey, we can't play this game with you. And if there again is an attorney out here who catches wind of this, who's desiring to come into Tampa, Florida to deal with this, the other issue is how many other cases are now tainted, because we now know they can't get around it. So even if something happens to me, which I don't want it to, I like to live a long life. Longevity has its place in my Martin Luther King voice. But anyway, the reality is everything that cat has touched is now potentially tainted. And all of you watching this now know it. Now, that being said, let's get to the dismissal case. You know, this is where the visiting judge comes in. So what I'm going to do is this right here. Let's go into finding some information. I want to show y'all some stuff. Here you go. Let's take a look at some of these documents really quickly. And again, this is actually going a little bit further than I wanted to, because we're talking about disqualification and inaccurately and effective disqualification. Here you go. Whereas it's been officially, I gotta find Ficarota's letter too. Whereas been officially has been made known to me that it's necessary to dispatch of the business of the 13th Circuit that a judge be temporarily assigned to duty and to hear the case of that state versus me. Here you go. Jorge Lombarga, under the authority vested in me as the Chief Justice of the Supreme Court of Florida. So that means the Supreme Court of Florida had to step in to do something. And by the way, that case was filed back in, was it June? Why are we in January of the next year before anybody decided to say, because we have a judge in our circuit as the witness, we should probably have either Mr. Doss go to another place as a change of venue, or have another judge come in. Had I not fought, I really believe that I'd have got railroaded significantly. But here you go. This is, and if, by the way, people, you do see the blue ink. This is legitimately what I got in the mail, and also what they had as well. So we got this thing from Chief Justice Lombarga. Let's see what else I can find in here. That's the order that released it. That's the docket page. That's it, dismissing. Wow, I know somewhere around there I actually have the letter. Let's do this since we're already in here. I'm going to go into my that's what I need to go into, because I want you to see the actual letter. This is what you can actually purchase this, but this is a let's do this. I want you to see the letter that he wrote. So let's try this. This might be it, people. Yep, this is it. See that date right there, people? Let's go back to the date that they filed this action. Six 6/16/2017. 6/16/2017. They filed the action. So here we are in 2018 in January, after a whole bunch of foolishness, and here it is. And by the way, you'll be surprised to find out who the chief judge is. That name look familiar to you all who just saw that flashing thing on the screen? And let's go over this really quickly. Because one of our circuit court judges is listed as a witness for the state of Florida in the above referenced perjury case in which the defendant is self-represented, I don't know why that matters, it appears the proper administration of justice requires that a circuit judge from outside the 13th Judicial Circuit be appointed to preside over the case. Therefore, I respectfully request that you appoint a circuit judge from outside the 13th Judicial Circuit to preside over the above referenced case. And there he is, Judge Ronald Figueroa. Now, maybe I'm a little biased, but I don't think it should have taken him that long to ask for another judge. So now we got that out of the way. So let's go back into doing this right here. Now we can go into the police report too. And actually there's a couple of other things. Let me try this page. Now here's what's going to be interesting. I'm going to show you. Come out of here. I want to show you what, according to the police detective, happened. Not according to me, according to him. Open up, man. There we go. So I'm going through this. And by the way, again, all this is available in the Dropbox because I'm giving you a sneak peek into what the Dropbox looks like. And I want you to find quite a bit here. But on one of these pages where he's going to say he received. Oh, there's that transcript that Judge Holder. See that? So he set this thing up to bring me in, didn't swear me in, oddly enough, and then began to ask me a bunch of questions. He took over and then told them to file it. So there's a transcript. Okay, so it's not in this one. I want to show you all the thing that jumped off the page to me, at me, literally, when I got this information. And by the way, they were really slow to get me the information regarding Victor and Holder. And by the way, see, they had the little mug shot of me. They had me looking like a stone cold criminal. I want you all to read this right here along with me. During the month of February 2017, I was contacted by the Honorable Judge Gregory Holder, who has a civil case in his courtroom regarding a pending bankruptcy hearing involving the suspect Doss. How I became a suspect, I don't know, but what's even more interesting is the circuit is in Hillsborough County. We all know bankruptcies do not take place in the circuit court, they take place in the federal court. Nonetheless, Holder related that the suspect filed a sworn document. The court advised him he was indigent, did not own any real property, had no source of income. Believing that a fraud was being committed, researched the Hillsborough County Property Appraiser's website and located real property owned by suspect Doss and requested this perjury be investigated by law enforcement. Now, he's saying this is what the investigation led to, but his investigation never gathered any facts that would show any of this to be true. Kind of interesting. I guess it's against the law for certain people to own property in Hillsborough County. That being said, let's go back to this right here.
And I apologize for being late. I had a traffic and finding my parking spot over here. So, y'all can sit for a moment. Let me just kind of figure this out. So, we are here in the 13th Circuit in the case of State versus Doss. Are you Mr. Doss?
Yes, Your Honor, I am.
All right, good morning.
Good morning, Your Honor.
And this is case 17-CF-009089A. And it's my understanding that we're set for trial this morning. And before we get to that, there's a couple things I want to talk about. I know there's a pending motion for continuance by the defendant. We have some speedy trial issues. And but first of all, Mr. Doss, I need to inquire as to whether you still intend to represent yourself.
Yes, Your Honor. And for some bookkeeping, I did a voluntary motion to withdraw the continuance. I don't want to continue.
Oh, I didn't see that. So, okay.
There's going to be a whole lot that goes on here, to include a new Ferretta. He and I discussing guilty versus not guilty, and a few other things. But let's just get to the part that's the best, at least to me, because I was internally a little bit concerned, but I knew the universe had a better plan. So let's get to the last part of this where he actually dismisses the case.
So the way the court ruled, they were going to rule anyway. If I had 170 houses and paid $300, they were going to rule. If I had 170 houses and didn't pay or whatever, they were going to do what they're going to do anyway. It wouldn't have mattered. They were going to take the properties or take their alleged.
Well, okay.
On property. I'm not. That's the argument that.
It's not a charge.
Okay.
That it was a sworn, like a C4 criminal motion, not that nature.
Okay. And so we jump up to the felony because it's
specifically because it's property. Basically the contradiction in I own property, I don't own property. I'm not. That's the argument that.
It's not a charge.
okay.
And let's go from a foundational perspective as well. The clerk also has access to records and information. And I guess unless you can bring the clerk in, she made the determination. That goes outside of Judge Holder doing investigation, which would be a violation of Article 2, Section 3 for separation of powers, as well as Article 5, Section 13 as canons, to try to investigate an issue so that he can call Victor. But the reality of it is that the charge does not fit. What he especially doesn't fit what he's explaining.
Well,
so
let me ask this. Does the state wish to amend its information and just...
At this point, so many days had gone by, they could not charge me as a misdemeanor anyway because the 75-day threshold for the state of Florida had already passed. There's a lot of good stuff that you're not going to get in this video because I'm not going to sit here for 2 hours and break down this proceeding. But I think we're going to get to the part where he says they bundled it, and that's where they were going to just grab a whole bunch of things and throw them all together to try to get a conviction, which is some BS. And by the way, I still don't have my houses.
Go under 77082. 775,082.
I'm sorry.
I'm sorry, 57082. 57082, the misdemeanor.
Does the state...
The state wish to amend its information in this case to make it not a felony, but the misdemeanor.
Well, for the record, I did extend that offer to Mr. Doss, which he rejected. However, because it's a misdemeanor and I am past the 90-day speedy trial period, I would have, had I had this case long ago, yes, I probably would have, but I couldn't do that now. It would be illegal for me to do so. You understand?
Okay.
I'm not trying, I wouldn't want to unlawfully do that because we're past the 90 days on that.
Maybe it is 90. Whatever it is, I knew he had already passed the time.
Got it. Okay, State, anything else on the materiality issue?
No, sir.
The state hasn't offered whether or not unless I missed it, did the state say that that would have affected the outcome? The state hasn't argued that that application affected the outcome of the trial, where I'm saying it absolutely didn't because what happened obviously happened.
State.
The only argument I have, Your Honor, is that without paying the filing fees, he may not have been even allowed to file his pleadings.
Wait a minute. Whoa, objection. Wait a minute. Either the state is either terribly confused.
It's all right. Quit while you're ahead, okay?
Okay.
Okay. All right. I find that the allegation is not material, and therefore the case is dismissed.
I accept Your Honor's findings.
Thank you.
All right. Do we need a written order that says that?
We will definitely need a written order, and then any outstanding motions are thereby struck. No need for further depositions.
They're moot.
Withdrawn.
They're moot, yeah.
And there you have it, a dismissal in my favor to the entire perjury action. I know a lot of that's kind of confusing. I may do a follow-up video where I give a narrative of the perjury proceeding, the final proceeding, because there's quite a bit there. But you can actually get it yourself through my Dropbox. You can go to my website, greghalderiscorrupt.com, order the Dropbox, and you can get everything for the most part that I've done over the last 6 or 7 years, maybe a little bit longer, since 2015-14, in that area. If you like what you see and you want to support the channel, please do. You see we have Cash App, Zelle, and PayPal. But let me show you something also. One thing is for sure, I'm hoping that I can get this. I'm going to get this started soon, because I'm about to run out of time. I've already filed my notice of action, so they're on notice that I'm going to bring an action against them. You know, definitely would love to have an attorney with some with a desire to make a splash, and definitely not lose out on what I think the value of the case is, because as we now know, there's a lot of people who are involved and put a lot of time, effort, and man hours into making this thing work. So, but that being said, I'm going to file it. I'm going to fight them anyway. I'm currently involved in litigation with State Farm, so adding a few more people shouldn't be too bad, and I'll use all the available resources that I've gained since then. It's always imparting, people. Oh, let me tell you this. See the 7682898? That allows you to pierce the veil of qualified immunity. I want to make sure in the state of Florida, under certain circumstances. Look up that statute. You may have a similar statute in your state. Utilize it to the best of your ability. So it's always imparting. Sometimes it's not about right or wrong. More important, it's about clarity. You never reach resolution if you're not willing to engage in honest dialogue, even if that dialogue is with yourself. Take time to hug the person you love and love the person you hug. On behalf of GD Non-Attorney Pro Se Consultants, I'm Greg Doss. I'm the infamous DJ Squid. I'm saying peace. I'm saying chicken grease. And I'm out.